Good evening, everyone. Thank you so much for joining. I welcome you all learners for joining. This is Annie from Into Legal World, and it is my great pleasure that we welcome our esteemed guest lecturer, Advocate Vatsalya Srivastava, sir, to today's session. Sir is a distinguished practicing lawyer at the Lucknow bench of Allahabad High Court, brings expertise in criminal law, civil laws, and RERA, with a strong presence in the legal fraternity. He provides astute counsel and representation to his clients, navigating complex legal landscapes with precision and dedication. Thank you so much for joining, sir. We are excited to learn from your experience and expertise. Also, learners, I request you please keep this session interactive and professional. Thank you so much. Over to you, sir.
Yeah, thank you so much for the lovely introduction. Thank you.
Welcome, sir.
Yes, so this class is of RERA, right, guys? Okay, so before starting this class, see, firstly, what I'll do is I'll tell you the basic itinerary. I'll tell you like how I'll go with the class. What will I teach you guys today? What drafts? Am I not audible? I guess I'm audible. Am I not audible?
Yes, sir, you're clearly audible.
Okay, because
Audible,
someone.
sir.
Okay, yeah. So, see what will happen in today's class. I'll tell you beforehand, before proceeding with the class. Today, basically, I'll teach you about the complaints of, how a complaint happens in RERA cases, real estate cases. I'll basically, firstly, what I'll do is I'll basically cover up the important aspects. I'll teach you basic, important, basic concepts about the complaint of RERA cases. Then I'll proceed with the basic draft of RERA cases. Okay. So this is how the class is going to be today. So yes, before starting the class, like for instance, I just want to know like, what are you guys, pursuing? Are you guys a lawyers? Are you students? Like, what are you guys doing right now? Because firstly, I have to take up the what is the mindset of the class. Okay, you guys are law students. Okay, that's good. That's fine. And is everyone a law student here? Okay, okay. Oh, some are advocates as well. Right, that's good. That's really good. RERA consultant. Oh, nice. We have RERA consultants as well. That's really nice. Okay. So, wait, let me just check the messages. Okay. Because I want this class to be interactive. I don't want, to bore you with the basic things. I want this class to be extremely interesting. Okay. So, students are the students, law students, advocates. Architect is also that's really nice. We have architect with us. Yeah, RERA consultant is there. Then working in legal firm as people manager. That's nice. We have a CS with us. Oh, that's really good. Company secretary with us. Junior associate in real estate. Great. Advocate, law student. We have in-house counsel with us. Oh, that is really nice. We have banking. Oh, we have a lot of diversity in the class. That is really good. So what I want from you guys is to be interactive today. I don't want that I don't want this class to go like I just start teaching and you guys just just listen to what I have to say. I want you guys to participate in this class as well. So okay, as we have CS and uh, real estate developers with us, so I'll increase this the level of the class I will take. Okay, so yes, that's fine. Let's start with the class, and I have already told you guys that how I'll take the class. Firstly, I'll explain the concepts. Then, if you guys have any kind of issue in that concept, you can actually ask me. I'll give you time. Then I have a sample draft prepared with me of RERA cases as I practice in the Allahabad bench of Lucknow High Court. Sorry, yes, Lucknow bench of Allahabad High Court. Actually, he said it, wrongly. Lucknow bench of Allahabad High Court. So I have a draft of my own state only. But beforehand, I'd like to tell you that the drafts are, maybe some things could be different in different states, but basically the draft is similar everywhere. Okay. So okay. So what? Basically, let's start with the very beginning. I'll teach you from the very from the very ground up. So what basically is RERA? Can anyone take up an initiative and tell us what basically is RERA? What is RERA? Uh, I don't think anyone is.
It is the act that
Okay.
regulates real
Yes.
estate.
Oh yes, yes, right. It is an act that regulates real estate.
So it's the authority that protects the interest of consumers in the real estate.
Yes, yes, yes. It also comes under this. Yes. Basically, what you guys understand is RERA basically deals with the real estate, right? So it is absolutely right. What the basic full form of RERA is, it is a real estate regulatory authority. It was formed due to the increase of real estate cases, so as to lessen the burden of the civil courts what we have in our respective cities. In order to lessen the burden of the cases there, the government what it did is basically it made a independent regulatory body by the name of RERA, Real Estate Regulatory Authority. It is very simple. It was basically this authority came into existence by the Real Estate Act of 2016. Before 2016 there was nothing by the name of RERA. Okay, so whatever RERA is, whatever we hear today about RERA, it basically came after 2016 amendment. So I told you two things. First, that what RERA stands for, and other thing is from which act it was established. Okay. So what it aims, what basically this authority aims to bring is, this authority basically brings transparency. This authority, as it is an independent authority that basically deals with the real estate cases, so it brings accountability as well. It has the members, the panels, the judges who sit here. They are retired judges. Sometimes they are practitioners of real estate. Lawyers also sometimes elected as judges in the RERA authority. So it basically, as this authority was basically created to increase accountability and transparency, so that the people who face a lot of issues in real estate cases, they don't have to face it, because a simple judge who is presiding over a civil court, he may or may not understand the very specific nuances of RERA. So what basically happens is with the creation of this authority is, it streamlines the RERA cases. It has basically streamlined the RERA cases, and stakeholders and important members who have a lot of knowledge of the legal practices of RERA Act, legal practices of real estate, they sit in the panels, and they basically adjudicate upon the disputes whatever comes to them. Okay, so I told you what aims, why this was made. It actually brings transparency because it brings accountability, and what it deals with is, I think every one of you must understood that it basically deals with real estate projects. So can anyone tell me what kind of real estate projects basically come under RERA? What types of real estate projects? Can anyone take an initiative?
So commercial and residential or mixed projects of.
Yes, 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 bang on, absolutely right. Uh, Basically, RERA, this adjudicatory authority, basically what it does is, the cases that it takes up, the jurisdiction upon what type of cases RERA has are basically two types. First is the residential real estate projects and housing real estate projects, and other are the commercial real estate projects like the malls and shopping complexes and shops. These types of real estate cases also come up under the jurisdiction of RERA. Okay, so then let's just go to the next step. So who can file a RERA complaint? Like, is there any kind of locus standi, or is this kind of a PIL that anyone, whosoever can come and can just file a real estate case? So what? Who can file a real estate case? Can anybody? Does anybody know?
So only the agree parties like the LOTs and the builder.
Okay. Okay. And just
Uh,
So the developers can also file.
yes, yes,
So the
and
promoter of the real estate projects and the allottees who have been allotted the land parcels or the apartments under the project.
yes, yes, yes. Right. But you guys are you all three of you are correct. But basically,
Landlord.
yes. Someone is saying something.
Landlords.
Landlords. Okay. Okay. It not exactly landlords, but yeah, in basic non-legal sense, you can say that those are landlords. Okay, but they don't under basically come under this. See, three parties, basically three type of parties who can file a complaint under RERA. First are the home buyers, the allottees. The person who buys the land, who gives their deposit to get a possession of a land after it is built. First are the home buyers. They are basically the aggrieved party. They can file a complaint. Others are the promoters or builders. The people who basically take up, get into a contract of agreement of sale or something with the home buyers, who basically have a job of basically to build the project, build whatever type of society or whatever type of mall they are trying to create, or whatever the whatever property the home buyer is trying to buy. The promoters of that property and builders of the property, they are equally, they have the power to file a real estate or not. Yes, absolutely, real estate as well as a RERA complaint. But the third type of people, see, these are simple nuances. These things you won't find it in basically law books, or or some kinds of cases. But when you start practicing in this sector, RERA sector, then you'll understand that real estate agents also, they also can file a real estate complaint. Do you guys understand what a real estate agent is basically, or I have to tell you guys what a real estate agent is?
Those who market the product to it, those who make sales, involved in the sale commission.
So basically, the middleman between the promoter and this who deals with all this buying and selling.
Yes. So yes, he's basically a middleman, who has contacted the home buyer to buy this property. Okay, then see, you guys have understood what type of people can file a complaint. Okay, then what are the common grounds? I think this is not something I have to basically emphasis upon, is that what kind of grounds, delay in possession can be a ground, or false promises can be a ground. You know, false advertisements can also be a ground, for filing complaints, and other grounds such as what actually I was taking up. I met a client of a RERA 3 days ago. What his dispute was a very complex one. His dispute was basically the change in layout plan. Actually, whatever the promoter, he shared a layout plan with the home buyer. What actually he did was, he later on changed that plan. He later on changed that plan after ascertaining, after taking back the money. So this was his dispute. This can also be a ground of filing a complaint, like change in layout or project plan without the consent of the home buyer. So other kinds of disputes that can come, as far as I can remember, are disputes of non-refund of booking amount can also be there. As sometimes home buyer they book a flat, or they book a residential or commercial property, and they give specific amount, but later on that amount is not refunded. This can also be a ground. Another ground can be what can be another ground? Another ground, yes, it can be also the hidden charges. A lot of cases are happening right now. I can, as far as I can ascertain, are there are a lot of firms who are becoming promoters and builders of properties, and they don't exactly convey the clients about the hidden charges that are that the client will be that will be imposed on the clients later on, but they don't transparently tell them this. So hidden charges that are not disclosed at the starting can also be a ground. So yes, these are the simple grounds, and I think these are in very basic English. I guess all you guys must have understood that what type of grounds are there. Okay. So,
How about any legal issues, sir?
I'm sorry.
How about any legal issues regarding land rent or development, something like that? Or the change of plan and something?
Yes, it could be a ground. Yes, I'm not exhaustively told you all the grounds. I just told you about just some important grounds. That right now, what type of grounds people are filing a lot of cases in there. As far as I remember, because I'm not teaching with any kind of module, I just I was just given a class today, and I started the class like that only. So as far as I can remember, because I practice, I can remember these are the grounds. Okay, then let's just understand how a RERA complaint is filed. See, from here, basic point of from a lawyer's perspective, what comes is from where if a client comes to you with a kind of RERA complaint, where do we file it? Firstly, every state, like in my state, we have a different specific RERA website. So in every case, in every state, there is certain RERA website that is there. Okay. Example that in UP it is known as the UP RERA, in Maharashtra it is known as Maha RERA. So these types of websites are there by the state government, the respective state government in states. Then what basically happens is there is a portal registration. You can also login portal is there. You can also register via that. When the portal is there, basically you can, if this, I'm basically telling about how complaints are there, as these are type of specific grievances. So these grievances can be, how can they be adjudicated upon is, you can log into the portal. You can there is a, then after logging in the portal, what happens is there is a complaint form that is there, in which you have to mention, and in which you have to enter all types of personal property details, and builder details, and whatever the grievance you guys are, as a client, a person is facing, and other type of relief, what kind of relief you guys are, or you guys as a lawyer or any person who is trying to sort from this. You guys can also attach, guys can also attach specific documents, like agreements, or any kind of checks or payment receipts that you guys have, or communication records that you guys basically have. You can attach that as well in the website. So, and after this, basically you have entered all the relevant details. You have attached all the relevant evidences with the details. Then basically what happens is you have to pay some kind of specified fee that is there. Basically, there is a prescribed fee for every types of property. It depends from property type to property type. So basically, a fee is there. Uh, I cannot tell you about the specific fee, but basically it ranges from 1,000 rupees to 5,000 rupees. It is not a lot of fees. It basically ranges from 1,000 rupees to 2,000. Sorry, 5,000 rupees. Okay. Then after paying the fee, you basically submit this complaint. Then you get an acknowledgement from the website. As soon as you submit the complaint on the mail, you will receive an acknowledgement from there. Okay. So this is the basic how you register a complaint, in an online way. Okay. Then you can also, register a complaint by going, manually to the RERA authorities, or to RERA, wherever the RERA office is there in your, basically in UP. There are two RERA offices we have. One is in Gautam Budh Nagar, another is in Lucknow. So you can go there as well. If you don't feel like filing this complaint, an e-complaint, you can go to the office, and you can file a complaint, in a written format as well there. So the draft that I'll teach you is the draft of written complaint only. Okay. So next, what comes is basically what uh, what I'll teach you after this. See, basically, let's understand what are the adjudicating officers and what are the RERA authorities. What type of tasks? See, in RERA, there are two specific types of officers. First are the officers that adjudicate upon the matter. Those are known as adjudicating officers. See, what they deal with is they deal with the compensation related issue. What kind of, after in your case, what type of compensation you will receive. The adjudicating officer, they deal with that. Then comes are the RERA authority, the basic authority of RERA. What they deal with is they deal with the violations like project delays, and non-disclosures. This is the basic different jurisdiction that is given to RERA authority as well as the adjudicating officer. As they two are not similar thing, they are specific different thing. Okay, and what is the basically, see, yes, one thing I forgot. See, uh, there is a time frame. There is a specific time frame for filing a dispute in RERA. So basically, what happens is, as soon as you file a complaint in RERA, it is upon RERA, upon the authority as well as the adjudicating officer, that they will, in every manner, try to resolve your complaint within 60 days of filing. This is an important parameter that was set by the state legislature in the act, that all types of cases that comes within RERA and comes under the jurisdiction of RERA, they will be, and they will this is not something that is on the books. This is not something that is just written. It is not applied. It actually is done applied. I have myself seen that cases being resolved within 60 days. This is what basic the legal what happens is when you create an act and you create a specific timeline for that. That is why what the acts that have came, the criminal acts that they have implemented, in 2023, the BNSS and BNS and BSA, the Bharatiya Nagarik Suraksha Sanhita and Nyaya Sanhita, Saksh Adhiniyam, what they will see. We as law students and as lawyers, we thought that our task will be, it was a humongous task. First of all, to learn the important provisions of IPC, CRPC, Evidence Act, and then the government comes like this, and they try to change everything. They they shuffled all the sections. It was a huge task. At the instance, what we thought when when the drafts came of those three apps, they were humongous tasks. But with the implementation, with the later on implementation, what lawyers, we as lawyers, as judges, as as we as the people of legal fraternity, what we are seeing is that the issues, they are being resolved in that case. Earlier, that cases used to take up a lot of time. There were a lot of nuances earlier. But with the implementation of these three new laws, what is happening is that the issues are streamlined in a specific manner. Every step, the government has exactly provided this timeline, like 60 days or 100 days or 90 days. At every important aspect, it is there. In investigation, a specific timeline is there. For for custody, there was earlier also there was specific timeline, but they increased the timeline in order to for the proper investigation. So the government, what it is doing is with these time frames, we used to think that the government has gone mad. They don't care about the lawyers or about the students. We are students, and a lot of students are preparing for judiciary exam as well. So they are also facing a lot of issues. But with the implementation of these acts, a huge drastic amount of changes are happening every day. Drastic amount of changes. Okay. So yes, let's get back to what we were discussing. Yes. Okay, so I've explained about the time frame. Then what are the remedies that are available, that complainant can avail? First, the remedy that can be availed is the very simple remedy of refund. That see, जज साहब मुझे कुछ नहीं चाहिए, I just want a refund. मुझे property से कोई मतलब नहीं है. I just want, what I care about is a refund. Then what another remedy can be availed is that payment of interest with delay. If there is any kind of delay in giving possession, or any kind of delay in transferring the possession of the property, transferring the sale of the property, then for that delay also you can ask for payment of interest with the specific months. Then comes this the compensation for loss or injury in case a lot of mental injury was faced by the complainant. He can demand any kind of compensation for that as well. Other remedy that can be availed is in case the possession is still pending, then timely delivery of that possession can also be claimed as a remedy. So these four types of remedy that are there in the RERA. Then you see what type of penalties are there. See, RERA Act is not a simple act, not a civil act. It is a, I'm not going to say that this is a criminal act as well, but yes, the penalties are specifically defined in RERA. So what type of penalties can be imposed by the adjudicating authority and by the RERA towards the builders or agents? They can be 10% of project cost can be taken up as a penalty. Other penalty that they can be imprisoned as well, for up to 3 months, 3 years. They can be imprisoned for 3 years as well. Then what type of drastic penalty that a home buyer or builder faces in case he does a lot of there are a lot of home buyers who have a grievance against it, is that they can their registration of RERA can also be cancelled. This is also a penalty that can be given by the adjudicating authority to the to the promoters and builders, that even their RERA licenses can be cancelled. And this is and this is not a very hardest task. Once a RERA registration is cancelled, then the builders and the promoters, they face a lot of loss due to this only. Okay. Then basically the appeal process, I think everybody knows that you can if you want, you can file an appeal in the RERA appellate tribunal within 60 days. If you don't confirm with the if you don't confirm with the basically what the RERA, whatever the dispute resolution system of RERA was, and you think that you are not fully satisfied with that. So within 60 days after you receive a formal formal judgment type of thing, formal judgment in your complaint, then you can you are eligible to file appeal to the RERA Appellate Tribunal within 60 days. And if you guys want, you can even file an appeal in the High Court as well. High Court also has jurisdiction on some RERA matters within the specific time. The specific jurisdiction is there, but you are eligible if you think that uh, the tribunal is they are also not doing their task arduously. So you want, you can even file a appeal in the respective high court of the state wherever you guys are practicing, or wherever the building or the property was situated. You can even go and file uh, appeal there. Okay. So as far as I think that I have basically told you the very simple basics of complaint, and I don't think that it is something very technical or difficult. This was because before starting with the draft, I like is that people, they must understand the specific things that are there in the draft. Okay, so as far as I think that I've covered all the important points, and in very simple terms, in very very common words, I've explained to you guys. I have not used any kind of legal terms as such. So let's just if you guys okay, let's just do this. I'll just teach you the draft. Then at the end we'll take up questions. Okay. So if you guys have any question, you can just take it up with me in the end. Okay. So now I'm wait, I'm just sharing my screen, and I have the draft with me. I'll show you the draft. Show the draft to you guys. Okay. Okay. Great. Yes. I hope my screen is visible to you guys. Yes. See, this is the draft that I have with me. This is a very simple complaint draft. This is how we draft the complaint in the tribunal that we have here. Okay. So I'll explain to you guys and keep highlighting with this with my marker draft. So the first and basic important thing is what you write. See, now I'll teach you the basic important aspects of drafting. Okay. So in order to become, in order to learn drafting, what basically I tell everyone, what I tell my juniors and what I tell the junior advocates who try to join the high courts is that before starting with the draft of not just RERA, of any type of draft that comes before you, any type of draft, even it could be a simple complaint of rent agreement or something like that, or even a simple FIR format or something like that. What basically you guys must understand is what you guys must know is the basic nuances of that law. So, you know, in order to draft any agreement or draft anything, you must have a basic understanding of that subject. This, I think, is very, very important. This will not many students, not many lawyers, they take this up in the very beginning of their careers, and they face a lot of problems. In the coming years, because they don't have their foundations are not very much built up, and they try to they try to make drafts not with the conforming with the law. Okay. So this is the basic what we write is where we are filing this complaint. Here it is written before the Real Estate Regulatory Authority, Uttar Pradesh. This we write in every type of draft. This is a very simple thing. We write in the exact same format. We bold it and we put it in capital letters and we underline it. Okay. Then comes the honorable bench number. We write the bench number. We keep it blank. It is upon the filing registry of the regulatory authority. They file the bench number here by themselves. Okay. See, I as a lawyer I practice in Lucknow, but as it is Uttar Pradesh, so Gautam Budh Nagar is also mentioned here. But it is fine. Complaint number, this is also allotted by the registry to you guys. Okay. What is important here is then you write in matter of. These are very, very important. If you just miss this, that in matter of, you don't know what repercussions this will happen. What will happen is that defect will happen in this complaint. Even yes, defect can happen in this complaint, and you will be called or you will be emailed that the complaint that you have filed is basically defected, and you have not drafted in a specific format. So this is why these are very important things. Okay. So before going further, Do you guys know why basically drafting is done? As I'm teaching you draft today, so why basically, in courts we have a specific draft for everything. Why we have a specific draft of format? Why we have a specific draft of appeals in high courts? Why we have a specific draft of filing a case in civil courts or normal courts? Why for everything the state or the governments, they have given us a specific draft for everything? Why it is there? What is the basic thought process behind doing this by the state? What was the thought process? Can anyone tell us what is the basic thing? Why is a draft is given for everything? Hmm? This is a very common sense question I'm asking. It's not something
To give an understanding of the situation.
Actually, the voice is cracking a lot. Hmm?
To give an understanding of the situation.
Okay,
Okay.
okay, okay. Anyone else?
Written form.
Written form. Okay, some not exactly correct, but yes, somewhat right. It is in written form. Okay. Then what is the basic essence behind it? Why it is in written form? So why not we just not write a complete specific format? Why not we just take up a paper, a simple A4 sheet paper? We write how we used to write formal application to the school, that to the principal of Fala school, or to the real estate regulatory authority, subject matter complaint, and respected sir, this, and then we sign. Why not we do it like this? If written form was the basic basic thought process behind drafting, is basically everything. Why everything that is in legal essence?
There
Why do drafting?
there would be some mandatory amendment that is required to be made
Okay,
in the
okay, yes, you guys are understanding, right? Necessary amendments, that is right.
Uniformity, sir.
Uniformity, correct. That is amazing. Yeah, uniformity is also good.
Whenever there is a standard call,
Hmm.
there is the grounds and prayers which need to be addressed. And if there is standardization for it, it becomes easier for the adjudicating authority to decide the case. That's why there is a certain format to it.
I guess that there can be no other perfect answer than what you have told us. This is the most perfect answer. Why basically drafting is done? Clarity, precision, standard format, proof, written. These are things that, yeah, I get it. These are important. But this was not the basic essence behind drafting. The basic essence behind drafting was, when a judge who sits in a court, what happens with him is, in every day he has to deal with more than, I think, in Lucknow civil court, a judge, a standard CJM or a standard civil judge senior division, what he has to deal with is more than 120 cases a day. So if there is no standard format for everything, what basically will happen is a judge will take a lot of time to understand what is there, to understand basically what is there. That is why there are drafts of everything. This is the basic whole sole reason behind this. For every type of legal thing that you file before a court, or every type of agreement that you do with other party, everything that has some kind of legal sanction to it has a different draft. What basically happens is, when a draft comes in front of a magistrate, what she was saying, that was absolutely correct. In different, in grounds specific aspects are written, in prayer specific aspects. So what happens is, when a file comes before a adjudicating authority or a judge, what happens is, he does not read the whole. He cannot read a whole. It is not humanly possible to read the whole file, to read every fact and everything about the case. What happens is, he asks the lawyer, okay, tell very briefly what happens. Then lawyer explains to him. Then he keeps turning pages. Then he sees the grounds. He just looks at the grounds. He sees, okay, 4 5 grounds are mentioned. Then he straight away goes to the prayer. He sees, okay, what the other parties demand. He just see the prayer. He uses his judicial mind. Whatever he thinks that if the prayer must be granted in that favor, then he grants it. If he thinks it should not be, then he rejects the entire prayer. and he says that okay, the prayer is not right, you can ask this any other. So this is the basic essence behind it. This is the very basic essence behind it. Every other thing, that basic format, precision and clarity should be there, that there is a proof of agreement, or it is in written format, and there is a less risk if every type of if everything we write it down, then absolutely there is less risk in that. So these are things that are around this essence. The basic essence behind drafting was this only. Okay. So yes, let's come back to what we were understanding. See, then we write the name of the complainants there. Then see the complaint. We specifically write that dot 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 complaints. This is specifically written. Then verses. We write it exactly VERSUS. We don't write it VS or V/S or V dot S. We don't write it like this. In High Court, in tribunals, you guys have to understand this very very you have to take this up as very important things. If you can note it down, then you guys should write it down, that these are very basic for drafting. That you write verses, VERSUS. You don't write it in very short form. The other opposite party's name is written here, you write that dot dot dot, he is the opposite party, to to tell the court specifically that this is the complainant and this is the opposite party. Okay. Then you write the basic subject, written submission on behalf of the complainant, name of the complainant and complaint number. Okay, this is what you write. That this is a complaint on behalf of the complainant. Then you write most respectfully shoot. This, see, these are the things that are first, some things that are there in every type of draft that I've told you. This is something that is most respectfully shoot. We write in RERA complaints. Okay. Then it is that these written submissions are being filed on behalf of the complainant for the kind perusal of his honorable authority. Okay. See, as this complaint is filed by a counsel, this is not something that is written by a simple home buyer. He goes to a lawyer, he goes to an advocate to file this type of complaint. So basically, what the counsel does is that he writes, the first line is that these written submissions are filed on behalf of the complainant for the kind perusal of the honorable authority. Okay. For the kind perusal basically means is for the honorable authority to basically understand the kind perusal for his for his perusal. Then we write, we have specifically, we give headings, introduction. See, this heading is there. That the complainant, name of the allottee, co-allottees if there are other allottees, have filed a complaint before the Honorable Real Estate Regulatory Authority, Uttar Pradesh, under section, you write the section of Real Estate Regulatory Act 2016, as section, under section 31 only complaints are filed. Okay. Give me a second, okay, I have to bring some more. Okay. Just give me a second. Okay, let's come back. Yeah, so we write that the complainant, we write his name, the allottee's name, and you write that he has filed the complaint with the Honorable Real Estate Regulatory Authority under section 31. You mentioned the section number, specific section 31. Okay, see, in all type of drafts, in what type of thing, what type of specific aspect of legal term that you are dealing with, you write the specific section in every type of draft, not just in RERA draft. In writs, what we do in high courts, in second appeals, in appeals, in any type of application, substitution application, whatever it is, we write this specific section under which section this is being filed. Because every high court act, as this is this is something as a power given to a complainant, so you have to mention to the court that under this section we are invoking the power that you have given to us. Under this section only we are invoking. Okay, you write this, then you write the bearing the complaint number. You write the specific complaint number over here. Okay. Then you write the relief, specifically mention the relief, that the complainant having sought following relief from the honorable authorities in the aforesaid complaint. The relief I've already told you, it it could be compensation, it could be refund, it could be getting the possession, timely possession. You can write any type of relief that it depends upon the it depends upon the complainant to complain what type of grievance he has. So it will depend upon the client that you guys have. Okay. Then we write the facts. See, we don't write the facts as a first heading. See, as a specific draft is there of a complaint, then the legislature must have thought about it. Why only introduction is written first and not the factual matters? So this is we also have a logic behind this as well. I'll teach you this logic also. Okay, why introduction is given first? Why not the facts? Then the introduction, then relief, or why not introduction, then facts, then relief? Because relief is something that is asked after explaining something. So why relief is given first and facts are given after the relief? This is something that I'll teach you later. Okay. This is the then facts of the complaint. Okay. Then see here what you do is listen to me very well and remember this. As long as you are in this field of RERA, or as long as you are thinking about practicing law in India, or thinking about being a lawyer here. Okay. Always remember, we write the facts in any type of agreement, any type of draft, in any type of thing. Because this is something that I've learned by doing a lot of mistakes. That is why I remember this very, very, much clarity about this. You write it in specific points. Okay, specific points. You don't write it in paragraphs. You take up any draft. You download any XYZ draft from your, from a Google. You do anything. You will find that draft. In that draft, there are specific points. In point wise, the draft is. There is also a aspect behind it as well. Okay. Firstly, point number one, that the complainant has applied for the allotment of plot. You write a basic factual matrix that a plot he has applied for this plot. The name of the project you write, then the number of opposite party you write, then amount of that amount, booking amount that you have paid to the opposite party to whom you have paid the booking amount. This is the basic factual matrix you write in the first paragraph of the complaint. Okay. Then you basically tell everyone about that an apartment plot unit villa bearing number this is was allotted to the complaint by the opposite party. Wide allotment letter. You write the letter dated when the allotment letter you receive pursuant to the application dated this. Firstly you would have applied for this, then only you receive the allotment letter. So you write pursuant to the application this. Okay. But at this juncture, it is pertinent to mention that the total cost of the set of applicant plot is rupees. We write the cost as well. As per the allotment letter that is given to them, then the complainant for the same sum of rupees opposite party till date according to the agreement of sale executed in the complainant. These are the basic simple factual matrix. This is very basic English that is written here. Okay. Then point number third, that as per the clause this of the allotment letter, as allotment letter there are this is why I was not explaining you why it is done point format. See, here it is written that as per the clause this, the agreement, the allotment letter which was received by the home buyer, that was given to the home buyer by the builder, by the promoter. That letter must have also been in the points only. See, every type of legal thing that I've already told you, we write in points so as to ascertain this. Here it is specifically written that as per clause like 1, 2, 3, or ABC, or 1.1, 1.2, 1.3, what was the relevant clause was there in that letter of the allotment letter, builder buyer agreement for sale, brochure, prospectus. That is why all these types of agreements, all these types of drafts, they are done in specific specific numbered points. They are not written in paragraphs. So as to create so as to create a clarity in the minds of the judge as well as the as well as the other party. Okay. So when this complaint will come before a judge, he will see the point number 3. He'll see, okay, in this point it is as per clause this. Then what he'll go do is he'll go to the next judge. He'll find out the allotment letter. He'll open the allotment letter. He'll go exactly to that clause. So you won't have to write whatever was written in that clause exactly here. You guys understand what I'm trying to say? You won't have to write what was given in that clause here so as to decrease, because these types of agreement, whatever drafting is done, it is done in very much clarity with it is not an essay. You don't write everything in detail. You write it in detail, but you do it in specific crux points. You don't write each and everything. It is not a letter that you are writing to someone else. So you write it in specific format, in a specific points, so as to make it so as to increase the clarity of that. That is why this is written in points. Okay. Then that opposite party offered the possession of allotment bearing number to the complainant. While later we have written letter dated as well. However, the complainant got the actual possession of the opposite plot. This on this. We write the actual date when the possession was received. Okay. Then that the opposite party applied for obtaining the completion certificate or occupancy certificate. See, once the possession is given, then the opposite party, what they do is they apply for a completion certificate or occupancy certificate. Okay. You write the name of the competent authority here. This paragraph is applicable only for the cases where the complainant has knowledge of this fact. See, this is something that is very simple. When you come to point number 6, it is written that on several occasions the complainant requested the opposite party through email or any other medium to hand over the possession of aforesaid unit or refund the amount paid to the complainant or opposite party, the case may be. See, now you are writing specific facts. First, see, in this format, firstly you gave an introduction. Then you told the adjudicating authority about the relief that you are asking. Then, in facts, you gave the basic details of property, the basic details of the opposite party. You told about everything. Then you come to the exact dispute. Before coming to the dispute, you are basically telling that on several occasions, what you did is you actually contacted the opposite party via email or via any other medium. You attached, if it was done via email, you attached email in a relevant annexures. See, one important thing about annexures is also there is that in drafting, annexures play a very important role. See, you cannot basically attach all the documents after after drafting something. You have for specific documents, you make a specific annexure. Okay. Annexure is nothing; it is just numbered documents. What basically happens is when this case will be filed, what will happen is after this case is filed, not after this case is filed, then after this complaint is drafted, what happens is whatever the documentary evidences that will be provided to the counsel by the complainant, whatever document evidence will be there, then what it does is what the counsel has to do is whatever the thing they were attaching. See here, what they were attaching. Here they were attaching a builder's buyer's agreement. Here, okay. Here they were attaching They were, as you see, they were asking for occupancy certificate. Here they are attaching some kind of email. So what you do is you write at the end is that it is attached by annexure number 1A, attached by annexure number 1B. So what this actually basically gives a clarity to the judge so that he can exactly, after reading this paragraph, he can go to that specific annexure. If it is written that it is mentioned in annexure number 2, then he can specifically go to that annexure. He can see, okay, see the basic email, he can go to that email. Okay. So annexures are also made. As this is a simple draft, annexures are not given in this, but in when you start practicing, when you take up these RERA type of cases, and annexures are also mentioned there. They also play a very vivid role in drafting. Very, very vivid role. These are very basics, ABCs of drafting that I'm teaching you, because this is not a this is not a basic drafting class, but as I'm teaching you this draft, so I don't know whatever classes I'll have with you guys or not, but I'm basically, this is my way of teaching, is that I take up everything. I try to cover up everything. I don't need another class for this drafting. While taking this draft only, I'll teach you all the relevant things about drafting. Okay. So I have told you about the annexures as well. Okay. Then that despite several requests of the opposite party failed to hand over the possession of the posted unit, refunded amount paid, complainant as a case may be. See, these are the specific facts. Okay. Then you write that the part completion certificate, occupancy certificate was obtained by this. See, what will happen is that, see, as this part completion certificate is obtained, so you attach this certificate as annexure number 1C here. Okay. So it will help the judge. So also you can attach annexures like this. Okay. That thereafter a sale deed, lease deed was executed between the complainant, name of allotee, and opposite party. You can write here. Okay. And see, these are the basic facts. So this is the apartment, plot of villa, and focus on a complaint. This you can also write that if it was, in case it was cancelled or terminated, you can write this as well. Okay. Then 10th paragraph is that the complainant has received the refund of rupees out of the total money paid. If any kind of refund the complainant has received, he can also mention that in this complaint as well. See, these are the basics. These are basic factual matters about the complaint. Then comes if there is any kind of other issue that is there. If there is any kind of issue, then you write the issues there. Okay. If any kind of material facts or any kind of issue that may have arisen due to this dispute, then you can write it here. Or statutory provisions that the the complainant intends to rely, you can write the statutory provisions here as well. Okay. Then comes the prayer. Very important. Judge, he just sees your introduction, he just sees your relief, and he comes to the prayer. Factual matrix, he does not read everything. He just listens to the lawyer. He just listens to the counsel, whatever he says. When he comes to the prayer, what you have asked, what you have basically prayed to the court. It is therefore submitted that the Honorable the listed regulatory authority may please to pass as prayed for in the complaints filed with the complaint. Okay. Whatever you have prayed, you have to, for whatever relief you have prayed, you have to write it here that what you can just request to the regulatory authority. So after looking into the facts of the case and after ascertaining all the annexures, all the documentary evidences that you have provided with the complaint, so that they can, if they are satisfied with that, then they can grant a prayer in your favor. If they are not satisfied with it, then they can even not grant a prayer in your favor. Okay. Then comes then comes now we are at the end of it. Then comes the simple date, very important. You write date, you write place, very important. This is date at this is place. This is first as date, place, wherever it was filed, and at what time, what date it was this complaint was filed is written. Okay, not the date of the dispute, not the date when the cause of action arose. Basically, the date and place here written is the date and place of whenever you are going to the registry to file this case. Okay. Then comes the complainant. As this is a written complaint, so the complainant himself, he cannot file this case. So what he comes is, he comes through the counsel of the complainant, through an advocate of some sort. You write the complaint's name here, you write the counsel, the advocate's name here, then even you attach a wakalatnama with the complaint if if it is necessary, it is deemed necessary, then a wakalatnama is also attached. Okay. So this is the basic format of a complaint. I have basically taught you the format as well as taught you the relevant things that are in the format. I have even taught you about the basics of drafting as well, and I hope that you guys have understood. I hope that you guys basically understood about this. And okay, yes. So let's yes.
Sir, I have one query.
Just take up queries. Yes. Okay.
Is there any specific format given in the rules for complaint or?
See, what happens is, via act, when an act is there, when an act is made, this type of format is not specifically given in that. With the emergence, with the growth of the law, what happens is, these types of format, it is not explicitly given in the rules, but this is a format that is basically, this is what I can say is that this is right everywhere. This is not given specifically as a type of draft in the act, but yes, this format is taken up in every type of. Okay, it's not given as a simple draft in the act.
Like in NCLT, there is an NCLT rules. There are the formats given for the petition or application,
Yes,
where there are facts, limitation, all these clauses are there.
In NCLT Act,
it is not in RERA, right?
No, it's not.
Okay.
So affidavit in support is not required along with the complaint while filing the complaint. Affidavit in support of complaint.
Yes, if you want, affidavit. Affidavit is something that is very, very important.
No, not separate affidavit. I mean to say in support of complaint.
Yes.
Simply,
if you want, then affidavit in support of complaint can absolutely be there. You can then just complaint cannot be filed. You have to make a specific index. You have to write first that is complaint is attached, then affidavit in support of complaint is attached. Then you can write the relevant annexures. Then you can insert the wakalatnama or an ID proof as well. But
yes,
can you share a draft of what you have just put up, because it wasn't clear at all?
Yes.
That is one. And second, sir,
yes, sir,
I have a second question. Can I just ask it?
Yes, absolutely.
So,
I will this draft that I have taught you guys, I'll send it to the admin. Okay.
Yeah,
so I hope that she can share it in the relevant WhatsApp groups. Okay?
I have the first question, which actually stems from the earlier question, which was that when he mentioned about the affidavit in support of the complaint, is that a necessity, or it is really entirely up to us of whether I need to attach it? That was the question firstly.
Okay. See, firstly, before going into the depth of it, I'll basically tell you in very simple words what basically an affidavit in support of complaint is. See, affidavit is something that, how can a judge with your complaint, how can he understand that whatever you are saying is right? For that only an affidavit is attached to the complaint. This is something that should absolutely be there, but it is not a defect. See, can you understand what I'm trying to say?
Yes.
That complaint, affidavit in support of complaint is something that is, that is an absolute necessity. But if in case affidavit is not attached, then this will not come up as a defect. In after filing this complaint, this will not come up as a defect. This basically affidavit is basically done. What we write in affidavit is that that the complainant is well acquainted with the facts and circumstances of the case. When you write that in case any discrepancy in these facts come into the knowledge of the adjudicating authority, then it will be the responsibility of the complainant, and he will take back the complaint. Something like that you write. I hope everyone basically knows what to do with this.
So my question, sir, is that is it mandatory? That's the question.
Yes, you should. I think as far as I can tell you, then you should in before filing a complaint and while filing a complaint, you should absolutely attach an affidavit.
So, sir, in your draft which you presented to us,
okay,
can you please send us a complete draft of the complaint?
Absolutely, sure. Yes, I will attach an affidavit in support of complaint.
Right.
See, this affidavit in support of a lot of applications, a lot of things are done. This is not just simply done with complaint only. Okay. In a lot of high court cases, this affidavit is attached. Okay, that is why I did not include this affidavit in this format of complaint, because it is simply there. But I will, if you are asking, I'll send it. Okay.
Please. That is done. And sir, you mentioned that the complainant cannot sign because it has to be through a counsel. Again, not necessary.
See, no, I did not say this. I say what I said, the complainant has to sign. Then, as he is not a legal officer of the court, then he is signing through then the advocate has also.
No, sorry, sir, I didn't frame it right. My question is that can a person do so without the counsel?
See, I don't think so. You should not, because see, there are two things why you should not do this. Because firstly, as a common layman, he does not understand what are the basic nuances of this. Okay, so what should be done is, as if there is any kind of grievance that a complainant must have, he should absolutely go to a lawyer. His lawyer, as he is the officer of the court, he is not, not everyone. You cannot go yourself and file a case in the high court. You have to have, a client, an advocate to represent yourself. Similarly, likewise, in complaint case also, you have to have a counsel to represent yourself. Okay, you cannot go to. It is not a in party hearing. These types of hearing are not done in party. The party is not responsible to come to the judge and to explain the facts. These are done as the lawyers. They are officers of the court. That is why these things are done by a lawyer. Okay.
Thank you. Sir, okay. I have another question, but I'll take it later, if you permit later.
Okay. Sir, I have a question.
Excuse me, sir.
With respect to this complaint in RERA.
See, do one thing. What I'll tell you. Okay. Write your questions in the chat. I'll address, I'm not going anywhere. I'll address each and every one. I'll, because this is creating a sort of situation, because like everyone wants to ask something, but yes, you can write your questions in messages. I'll take up the message and that exact, numbers. Okay. I'll take up the question first, then another question, then another question. Okay. Just do simply write your question in simple terms in the message. I'll take it up. Don't worry. Okay. Okay, so I can see that Ankita Roy, she has asked how a promoter is different from a developer. Okay, see, what a promoter is, what a developer is. A promoter is basically a person or a company that basically constructs and develops, or sells the real estate project. That is a basic definition as per RERA of a promoter. Okay? He is a builder. A developer comes under the ambit of the promoter. Okay? As in a Venn diagram, you must have understood that promoter is a big entity. That under the entity of promoter, the developer comes. Developer is usually a person that is involved in constructing and developing that property. Okay, so this is the basic difference. If you want to, this is basically legal status given to both these parties, and a developer basically comes under promoter. These two are similar. They both construct and develop the properties, but a developer comes under the ambit. Okay. Projects prior to RERA are covered under RERA Act. Okay. I can see, okay, a lot of questions are coming. I can just, I'm just doing some water. Okay. Okay. Yes, projects prior to RERA are covered under RERA Act. See, yes, projects prior to RERA are covered under the RERA Act. It is not this is not a Hindu law that this is not a prospective law. It is a retrospective law, but conditionally. The projects, not every project come the projects earlier than prior to 1 May 2017 come under the RERA Act. But yes, if the project was completed before uh, 1 May 2017, it was completed before. See, there is a difference. If it was completed before 1 May 2017, then the RERA does not apply. Okay, then the complaints cannot be filed under RERA. You have to go to the specific civil courts. But if the projects are completed after 1st May 2017, it does not matter when they started. It does not matter when you received any kind of the completion certificate or something, some sort of that. But yes, if the project is completed after 1st May 2017, then yes, they come under the RERA. Okay. How to make a party to the complainant? How to make a party to the complainant? I don't understand this question. What are the RERA rules and RERA Act? See, a RERA Act is a specific act that is drafted by the legislature. RERA rules are also drafted by the legislature, but what happens is RERA Act is the basic body, and rules are the arms and legs of that. What basically helps in understanding on the interpreting of the RERA Act, understanding the provisions of it. The rules basically help in interpretation. This is the basic difference of RERA Act and rules. Okay. What Vishal Basant is asking, what to do if a regulatory body doesn't respond on an application filed by developer for registration of the project. See, if the regulatory body is not responding on the application that is filed by the developer for registration of a project, then you can refile the application to the regulatory body. As a home buyer, what you can do is you can also, even as you have a locus standi here, then you can also try to find that, and find try to find the nuance why it is not happening, and then you can even go to the specific civil court if you guys want, a specific high court in case of inoculatory application as well, if the body is not functioning as per the procedures. Okay. Sir, I had a question in regard to whether the cases where people are allotted a property by DDA or Ghaziabad Development Authority or any other government organization, does provisions of RERA apply to such properties also? Yes. Yes. See, the provisions. See, how can I tell you this in simple language? See, simply understand this like this. The property are of two types. Okay. Uh, Private properties and the properties that are given by government. Okay. Private properties are the properties, the people who are the people who are the promoters, the private developers. That Ansal and DLF. These are the private developers. But yes, the properties that are allotted by the government, the RERA applies to that property as well. Okay, if the public authority is acting, if the government is acting as a promoter of that property, like the DDA that you have said, that the Ghazia Development Authority, the GDA, it also municipal corporation, housing boards. If they are constructing any type of property, residential or commercial land, then yes, they are considered. See, if you read the provision of Section 2ZK of the RERA Act, you'll understand that as a government body, they also come under the ambit of promoters. So as they are promoters, absolutely a case can be filed against them, and absolutely RERA acts as a governing body for them as well. Okay, and there are as, but the thing is that this has specific limitations to it. There are some government projects upon which RERA does not apply. Projects such as construction of station construction, anything of that sort. These projects, they don't come under the ambit of the RERA if they are done by the government. Okay. Then I have a grievance against a builder who is blatantly abusing the law. I have a question, which if you permit, will okay. You can ask after I've done taken up all the questions. Okay. Does land use determine RERA applicability? Yes, yes, absolutely. Land use. See, I've told you this. In the very beginning, that if the land use, commercial and residential, these two types of land uses only comes under the ambit of RERA. If the land is being used for any type of mining purpose, or for any purpose such as establishing any industries, then or the example that I gave you, that for purpose of erecting a government office or for purpose of erecting a police station or public hospital, then upon this RERA is not applicable. So land use is very important. While I noted your advice that it is better to have a lawyer to file a case on our behalf, it is mandated by RERA law or any law to have a lawyer or any eligible to file a complaint case with the RERA, also to register projects with the RERA and anyone submit details for registration without RERA. See, I told you the very beginning. You have an online portal as well. You have an online portal that is specifically there for these cases only. If you want, you can just log in and register in that portal. You don't need a lawyer there, as it is an online portal. Like the cyber complaints that are given, that are there, as we are in the cyber era. So all type of cyber complaints that are done online, you don't need a lawyer. You just need to register there. You have to mention the relevant details, attach a relevant screenshot, and upload the screen. Simply, if you want to file a complaint via the online complaints, then you don't need a lawyer for that. But yes, if you want to go to a court, if you want to adhere to a specific format, and when these type of RERA complaints are done in front of the educating authority, then what happens? Then basically, the the importance of lawyer. Okay. Then small time builders are required to register with state RERA. Yes. Like small time builders, they are not required to register with the RERA. Like small time builders, if you have takedars and other people that are there, they are not required. If they make specific plots, 1 or 2 plots a year, they are not required. But yes, if you are making a housing society, if you have a big 1 or 2 acres land or bighas of land, and you are trying to establish a housing society in that, or you are trying to sell that land there, then in that cases you are required to register with the state. But small time builders, they are not required. Okay? Is it necessary to mention carpet area as per RERA Act in the draft while filing a complaint? Yes. This is a very, I will say that if you guys want, you can mention this. The carpet area of that property, this will, increase the, the susceptibility of a judge. He will be able to ascertain that, okay, if the property is that big, then the grievance is a big, this is a big grievance. And this also helps. Mentioning a carpet area also helps. If you want, it will, see, these types of things will depend from, the grievance of client to client. If your client is demanding you to write this, you can absolutely write. See, this is not this is not a draft that is a specific draft that is followed. It's a simple draft. You have to write it like that. But in factual matrix, whatever you want, you can mention. Okay. How to make necessary party in a complaint? See, necessary parties. There are 2 types of parties according to what we have in the civil procedure code. First are the proper parties, or the necessary parties. See, the difference between proper parties and necessary parties is that I'll come to this question. The difference between proper parties and necessary parties is that a proper party, if the case is filed without him, then also the case does not have any repercussions. The case is basically done in that way. But if yes, if the necessary party is not there, then the case it comes to a strike court. The case does not happen without if the necessary party is not. But how to make a necessary party in the complaint, if you're asking, is that then you can add the necessary party, you can write the the necessary party, you can mention the builders. If the builders has any kind of agreement with some other person, you can write their name as well. You can write the name of the agent in the necessary party also. Like these, you can add the necessary parties according to you. As it is a private complaint, this is a complaint tendered to the court. If a person has legal basis in your case, then you can mention him as a necessary party. If not, then you have it will be upon you to to tell the court that why he is a necessary party, why without him the case will not go forward. Okay. Then Akash, what is that? How to start a drafting any draft if no specific format or no previous application is there, and how a person can start learning to draft any draft if the person don't have any good skills. Let's see. Basically, the thing, see, not in, if you ask me, very simply that do I think that I have the relevant good skills in drafting, and I'll say I don't. No lawyer who is in his prime, who is even 70 years old, he can draft anything in a perfect format. There is no such thing as perfect. What things are in a draft, what are important is that you have to mention the specific things. You have to write all the essential things. As soon as you are writing all the essential things and you are adhering with the format that is there, see, there is nothing of which a draft does not exist. There is nothing in this world that exists, any kind of legal complications, any kind of application, any kind of draft of which a draft does not, or if a draft of which a draft is not in existence. If you go to a lawyer, you will go to the court, you ask the munshis there, they specifically a draft is there for everything. If there is no draft, then you can just write the application in a very simple, specific, specific, in formal application as in that way. This is it. And in order to learn drafting, I think a lot of these websites I'm seeing right now. That I'm also teaching. I used to last week I used to teach this drafting course to students of SRM University in the south. That is there. Last week I used to teach the students there. There was a collaboration with a specific brand there as well. I was teaching this drafting. So there are a lot of drafting courses that are available online. I'm not gonna name them, but you guys can research according to you. If you find it relevant, you can absolutely take up the drafting course as well. Because in law colleges, the drafting that is teach the shitty drafting is taught. I don't care if anybody can record me and say you can record me and then play anywhere. But I can say exactly that in law schools, drafting is not taught. And see, drafting is one of the most important things that a lawyer must understand. A lawyer must know. It is one of the most important. They teach, things such as company law and sports law and aviation law. That's of no use. Drafting, that is why only this 3-year practice came. A lot of students, a lot of people, including me, as soon as I heard that there is a judgment, because I was also at one point of time in my life I was preparing for judicial. And I am, if you ask me, I'm still, if I get a chance, then I will absolutely able to, I'm eligible to, apply. But when I heard, I thought, because if I was a recent graduate right now, then this would have come to me as a great shock. But the judges, they have thought about it in very depth. That is why they have created this practice. Because earlier what was happening was the students, they were, as soon as they were graduating from law schools, they used to think that, okay, now I'll start preparing for judiciary. They don't used to have any kind of second option with them. As a lot of, because 90%, as there was a survey I was reading a while back, 90% of law students, they have zero background. They are first generation lawyers. So they used to just start with the judiciary preparation as soon as they used to get out of law school. They used to spend 4-5 years in judiciary preparation, and then used to attain age of 29-30. They used to think, they used to look back and see that they don't have anything to fall back on. That is why this thing has created by the judiciary. They have said that you have to have a 3-year practice before even being eligible to give a judiciary exam. This is because, see, this is made as a rule. This will help students in a way that as they have 3 years practice, they keep on giving exams. In case they don't clear it, then they will have a second option. They will have something to fall back on. As they have earlier practiced for 3 years, or earlier they have gone to the courts for 3 years, then they have something to fall back on. Okay. Okay, so yeah, I was actually basically, I get I get swayed away by things. Yes. So how to okay, drafting this again. How AFS can be drafted in a phase-wise project? I think this is a very specific question. I don't have any much knowledge about this. That I don't even know what AFS is. Can be drafted in a phase-wise project. I don't understand. Buy a purchase plot in a project marketed as residential, applied for land conversion from commercial institutional land to residential loop. Okay. Local agencies rejected the conversion. Does it fall under the RERA as promoter claims no fault? See, this is something that is of the case related to land conversion. Before basically, telling, I can exactly tell you, I have to basically see the exact phase, the facts of the case before even telling you that does this fall under the RERA or not. Because see, as this is a purchase plot in a project that was marketed as residential. Okay. Or later on, if someone is applying for land conversion of that specific residential to commercial, then I think that I have to basically understand the basics of the case first before telling you that if this will exactly follow the RERA. Then how does the land, that the farmlands layout more than 600 square yards need to be registered under RERA? See, I don't have much information regarding this. I have bought information. These are the specific facts that you are asking me. I'm a lawyer of this. I am not a RERA consultant with this. I basically what I come is when a specific grievance is filed before me, I take those up. But this does farmland, I have no idea about this. That farmland of 600 yards needs to be registered on RERA. I don't have it. Okay. So thank you, sir. Is it possible to learn? Yes, absolutely, absolutely. I learned this drafting by myself only. I have a specific book. It is of 500 pages long. I don't have the book manual, but I have a PDF of it. It is in my tab. I in the very beginning of my practice, I used to take up drafts. I used to learn drafting from there only. There are specific nuances to it, but yes, I take up drafts from there only. Okay. Evening, sir, do you take on internships? As of now, see, I don't get much time from the morning 8 o'clock. I leave my home, and still right now also I'm in my chambers. So as of now I'm not taking any kind of internships, but yes, you can absolutely connect. I'll share in the chat box. I'll share my LinkedIn. If you guys want, I can share my LinkedIn here, and and then let's just go with it. Okay. Okay, kindly share as a PDF. Yes, absolutely. I'll share as a PDF. Okay, sure. I'll both of these two things I'll send with the admin that you guys.
Excuse me,
Yeah.
Vatsal.
Yes.
I have a question actually.
Okay, sure.
There are in newly built bus stations and railway stations, the railway authorities and the GS, for example, the state transport corporations are leasing some of their premises for long years, for at least 60 years, 70 years, and they give contract to the developer. Oh, sorry, a builder. What they do is they after lease that property to the individual buyers.
Okay.
So will they get covered in this RERA?
You are asking me that the newly bus stands or bus stands that are created, railway platform that have been created. So what the roadways department, what they are doing is that they are leasing the premises to
They are
the builder.
leasing the premises for a long time, for 60 years, 70 years, to a developer.
Okay.
And give rights to transfer the property to the individual devotees.
Okay.
Who wish to do business on this premises.
Okay.
Will this get covered? And if it is covered, the allottee who will be the responsible to pay the compensation or resolve the issue? The GSRTC or the developer one?
See, the thing is, under the transfer of property act that we have right now in force in India, the lease, whenever any land is leased to someone else, the ownership of the land is not transferred. Only sale is a simple way in which the ownership of a land is transferred. And whenever a sale is happening, then only I have told you that whenever a sale of residential or commercial plots or residential or commercial land is happening, then only RERA comes. But when the first thing that you told is that the land is being leased by the state the transport board to the promoters, then I don't think so. This is a simple civil case. This will come under the Transfer of Property Act, and I think the RERA will not have any jurisdiction over this. I think the civil court will basically have jurisdiction, because lease is something in which you are not basically transferring the ownership of the land. For 60 years, you are just giving the possession of a land to someone else, and after 60 years, you can take it back. So what basically will happen here is, as far as I can tell you, is that RERA, I don't think so RERA will entertain this kind of complaint, because in very simple format, in very simple legal format, a lease, if you understand in common sense terms, then lease is something in which just possession is transferred. The ownership is not transferred, and until and unless the ownership is transferred, I don't think RERA will have any kind of say in this. I don't think, because maybe I'm wrong or maybe I'm right, but as far as I'm able to ascertain that when a lease is given, then the property is not transferred. The properties rights are not completely transferred. They still lie with the state transport board only, until unless they are leased. They can they can just for some years, for 60 years, they can give it to promoters. They can establish commercial places there. But I don't think so. After 60 years, when the lease will end, then the property will it will rightly jump back to the state department, the roadways department that earlier leased the property. So I don't think so these disputes will come under RERA. But yes, if fraudulently the builders or the promoters, they are advertising this property as the to the home buyers that they can buy this property, then yes. If this is happening fraudulently, this is happening, then yes, this can come under RERA, because this a complaint can be filed in terms of false representation by the builders and home buyers. But as far as determination of land is concerned, I don't think so. I think this will lie completely with the authority of the civil courts, as this is a transfer of property case. This is not a case of
Yes,
rates.
yes. The next question is that how RERA will deal with the cases like when allottees haven't paid the amount which he has promised. Simultaneously, he has
Okay.
also taken a fund from a bank
Okay.
to fund on an agreement for sale basis. And at one hand, surface proceedings are going on. At one hand, builder has initiated the complaint against the allottee.
Okay.
RERA has passed the orders. So how the end result will come in these things?
See, as far as I can tell you is that uh, when a grievance is filed with RERA, what they basically see is they basically try to see who has or who is more at fault. Okay. Firstly, this what they basically do in simple cases, that they try to understand that okay, if both the parties are saying that the other party is at fault, like the builder are saying that the allottee is at fault, he's not trying to pay the money, or he's trying to get out of the agreement, and the allottee is saying that the builder is at fault. So what the RERA does is that it basically compares both the two things. What it does is it basically compares, and whatever decision they take, if they think that the buyer is more at fault, then they try to adjudicate the dispute according to that. But yes, they keep in touch.
What practically is happening now at ground level? What I have noticed that generally in agreement for sale cases, banks and financial institutions are passing the money directly to the developer.
Yes.
They are issuing the check on the name of the developer, right?
Yes. Yes.
Okay. Builders or the builder or developer goes to RERA, made application for the cancellation of sale, the agreement for sale with the allottee, and transfer that property to someone else.
Yes.
Is there any kind of specific provision which deals with this kind of situation?
See, this can come, if they want. This can come as a fraudulent practice by the promoter and the builder, because see, firstly, see, because of these things, there are the importance of letter of conversion and letter of acceptance, and these things come into play. As if they have come into an agreement, they have come to an agreement of sale with one party, and that party, after coming to an agreement of sale, they have contacted the bank, and the bank has subsequently, with looking into the agreement, they have transferred the money to the builders, and the builders, he fraudulently, what he does is goes to the RERA, he files a complaint case, and he will transfer the property back to someone else. Then yes, the RERA will take up this case. This is a very severe case, and I think a lot of home buyers right now, they
No,
are
actually, I am asking for a specific question which deals with this kind of situation.
as far as I
Under the
know,
regulations.
I am not right now. The specific regulation is not coming into my mind. I can just tell you this, but yeah, if you want, I'll just share my number. You can if I'll just if I get to it anything, if I find anything relevant to it, I can just send you that on WhatsApp. Okay, I'll just save your number. I'll send my contact in the chat.
No issue. Thank you.
Thank you so much.
Sir, if you're okay, may I ask my question? It is
okay. See, I have see, the thing is, it is 9:25, 9:30. I've shared my contact in the chat box. Whatever questions you guys have, you can just send them directly on the WhatsApp. Okay. I think it's not an issue. I'll take up the question. Don't worry. Okay.
Thank you. Can
Okay.
I say,
Yes. I've shared my,
so the question basically is that if a builder has
I've shared my. I'm telling you, I've shared my.
Excuse me, learners. If you have any queries, you can just directly ping to Sir. Sir's
I've
contact
shared my
number is
number.
there in the chat box.
Okay.
So
Yeah.
you can, you
So
can ping on your queries there.
So are you closing the session now?
Yes.
Yeah,
Yes.
we're
If you
closing
want
it because
anything, you
it's
can ask me.
already 9:50,
Okay,
right?
okay, thank you.
Thank you.
All right. Thank you so much, sir. A heartfelt thank you to you for taking the time to be with us today. Your insights on topic discussed were truly searching and thought-provoking. We are grateful for the knowledge you share with us today and the inspiration you have given to us Thank you once again. And thank you so much, learners, for related queries. You'll get update on the group. Thank you so much. I'm ending this session.